Hello, friends. I welcome you to the Legal Breeze for an important discussion about the need to penalize the marital rape. Marital rape has no place in the constitutional democracy like India. So, we'll be dealing about it. 11th May 2022 happens to be a historic day because that is the day on which the Honorable High Court of Delhi has made a historic judgment. Particularly, the division bench was led by Sri Justice Raju Sigda. He single handedly fought for the freedom of women against the marital rape, protecting the dignity of women enshrined under Article 21 of our Constitution. We will be doing a case law analysis in this particular video is concerned. We wholeheartedly welcome this judgment rendered by Justice Raju Sigda. However, we regret, as he has regretted in his own way, that he couldn't convince his brother judge, Sri Harishankar Prasad. However, it has been certified as a fit case for appeal before the Supreme Court. I believe the case will be decided in favor of the petitioner, that is Kushbu Sifi versus Kushbu Madam. She has brought the case through an NGO. She has been suffering because of marital rape, repeated marital rape committed by her husband. There is no medical facility made available to her to treat her injury, and there is no support from her in-laws. Finally, she has to take shelter from with the assistance of an NGO. Through that NGO, she is fighting the battle till now. Because finally, till the Supreme Court strikes down or agrees with the judgment rendered by Raju Sigda, there is a long way to go to see that the marital rape getting struck off from the statute book of IPC is concerned. As I have narrated the facts, the what has happened to be the petitioner is Khushbu Madam. But see that generally in the sexual crimes, there is a mandate that the victim identity and name shall not be disclosed. But even this facility is not available in the case of married women. What are the important cases relied upon? The following cases has been relied upon by the Honorable High Court, particularly Justice Raju Sigdar, and by the petitioner. A. Mithu versus State of Punjab. B. Joseph Shaini case. Then Navdor Singh Zohar case. Then independent thought. These are all the, and K. Puttaswamy, that is Aadhaar case, a right to privacy case. These are all the important 5 cases all of us should remember, which has been very highly helpful in creating a transformative approach in relating to the rights of victim, particularly against the marital rape is concerned. Okay, we will come back to that little later. In what are all the important provisions of the Constitution has been relied upon by the petitioner as well as Justice Raju Sigda. Article 14, Article 15, Article 19 1A and Article 21. In my opinion, the Article 23 and 24, that is right to against exploitation, should also be relied upon, because that is also very helpful, because marriage is not a forced labor. Marriage is not a universal license to sell the to make a wholesale and retail selling of the entire right to dignity, sexual autonomy, bodily integrity, bodily sovereignty, whatever you call it, of the women has been subjugated in the name of marriage. To put it differently, marriage is not a license to commit sexual violence, particularly rape against women is concerned. So this understanding has come to finally at least to one High Court judge today, but I hope this will be followed by the Supreme Court in the times to come, because when the Nazi Foundation case has been pronounced by the Delhi High Court, it was obstructed by the Supreme Court once upon a time, but later on the Supreme Court has agreed in striking down Section 377 partially, and that is what Navdor Singh Zohar case is concerned. Okay, what is independent thought? This is very important. Independent thought, this is the case in which the Honorable Supreme Court has applied a doctrine called doctrine of reading down. This is very important. Instead of word 15, please remember there are two exceptions to section 375. 375 defines rape, 376 punishes the rape. Okay, please remember that. There are two exceptions to section 375. One, medical procedure. Through medical technology, if you are inserting anything through the vagina or uterus of the women for the purpose of fertilization or procreation, then that is not amounting to rape. Again, when the husband takes forcible intercourse or sexual intercourse with his wife when she is above the age of 18, is not amounting to marital rape as of now. But originally, when the IPC has come into operation, it was just 10 years. Later on, the statutory rape has been enhanced from 10 to 15 by the Criminal Law Amendment Act 1983. Then now, in independent thought, the Supreme Court has rightly read down the word 15 and made it as 18. So today, if any husband commits or enters into sexual intercourse, even with his own wife, if she is under the age of 18, he will be penalized because this is amounting to rape. Now, what this judgment rendered by Sri Raju Shikdar has done, it has removed the upper age limit of 18 as infinite. So, irrespective of age, irrespective of marital status, if the husband commits a rape upon his wife, even if she is above the age of 18, it will attract the penalty because this exception has been struck down. Now, what is the arguments in favor of this? This is very important. I am also agreeing with this. You would have heard a case called Mithu versus State of Punjab. There are two punishments for a murder. A murderer is concerned, or a convict of a murder is concerned. You all know Section 300 defines murder. Section 302 punishes the convict of murder or the murderer. Okay. Section 302 gives two options to the court in providing punishment to the accused or convict. One, life sentence, then death penalty. Whereas this discretion has been taken away by Section 303. If a life convict again commits the murder, he will face only death sentence. Now, this has been treated as unconstitutional by the Supreme Court of India and Mithu versus State of Punjab on the simple ground, just because a man or citizen has become a convict, he doesn't lose his fundamental right under Article 14. 14 confers two important rights: equality before law and equal protection of law. So what is missing in the case of married women is that unmarried women are entitled to punish the rapist, whereas the married woman is not entitled to punish the rapist when the rapist happens to be her own husband. That is very important. This is what the case law makes it very clear. Rape is a rape and it should be labeled as a rape, and rapist is a rapist only and nothing but a rapist. That's very important. Whatsoever his relationship is. He may be husband, he may be father, whatever it is. This is very important. So on that similar line, I have told you, independent thought has enhanced the age limit from 15 to 18 and made feasible penalizing the marital rape committed by the husband. Now it has, by striking down exception 2 of section 375, now husbands have to undergo equal punishment. It is being given to other accused also, because in criminal law, relationship has no material at all. That is what has been made clear in this particular judgment is concerned. What are all the other important judgments relied upon? Foreign court judgments, right? I have told you Puttaswamy case against Puttaswamy case. Justice Chandrachud went on to say that even a right to abstain from sexual intercourse, right to abstain from procreation, all these things becoming part of right to privacy under Article 21, vested with the women. But in the same guise of privacy, there are lot of marital sexual violence goes unaddressed. This has been successfully demonstrated by the High Court, particularly by Justice Raju Shigda, where relying upon the National Family Health Survey report. This has made it very clear almost 99% of marital rape is committed or sexual violence is committed to the victim, particularly to the women, only by their husbands and their relatives or by the former husbands. And 99% of them is not at all getting reported. This is a very important fact. So those who raise hue and cry that once marital rape has been permitted, this may lead to huge misuse is not at all worthy. That has been rightly pointed out by the Honorable Judge Sri Raju Shigda. So that is very important. And then I think I need to tell you few important foreign cases. I think I told you there is a case Clarison versus UK it's a very old case. Then RVR versus UK. This case has been decided by the European Court of Human Rights. And then you have People versus Libeda. This has been decided by the Supreme Court in US. Again, punishing the marital rape is concerned. That is very important. And even a case decided by the Nepal Supreme Court, Philippines, has also been relied upon by the judge in this particular case is concerned. That is very important. Then what are the important provisions relied upon? Article 14, 15, 19, 1A, 21. But I have told you 23, 24, that is right to against exploitation should have also been added. And international instruments, particularly Article 1, 2, 15 of SEDA and other important international instruments have also been relied upon. The case is assuming importance, particularly the judgment rendered by Sri Raju Shigdar is not only important for understanding the consequences of marital rape, while it's placed in a constitutionally democratic country, it is also teaching lot of things such as the difference between arbiter dictum and precedents, whether the High Court can override the judgment rendered by the Supreme Court in the name of per incuriam. Many doctrines, including doctrine of severability, inversion test, all these things have been beautifully explained by this particular judge's concern. He also traces the history of the entire rape law in this country, right from drafting stage of IPC. When it was drafted, it was there as class 359. Later on, it was numbered as section 375 in IPC. And he has traced the law up to 20 amendments, something like that, punishing the rapist with death penalty when he is raping a girl who is below the age of 12 years. To that extent, he has covered. He has also cited or relied various reports, including Verma Commission report, 172 report of Law Commission, various parliamentary standing committee reports. All these things he has relied upon in support of his judgment. We hope it will go in long way in empowering the women is concerned. Supreme Court will also take such a similar view so that the dignity of women is being protected. And it should be noted, above more than 50 countries, the marital rape is being penalized. That is exception to rape committed by the husbands are abolished. That's very important. So there is no place for exception to 375 in the modern day constitutional jurisprudence. Constitutional morality demands this. That's very important. So what is the ratio of this judgment is concerned? He has successfully struck down exception 2 of section 375, section 376b and 198b has also been successfully struck down. We hope good sense prevails sooner rather than later. Thereby we can create inclusive, a viable, a sustainable India. That's very important. Please understand, marriage is not a license to commit rape. Husband should be more compassionate. Husband should be more love. What is that? It should be more lovable. In Tamil we call it veliye pairamiye kodadunu solli. It means the security god himself cannot become insecurity. He himself cannot be an aggressor. The protector himself cannot become the aggressor. That is what happening. That is what I'm not telling this. This is what the National Family Health Survey report says. So we hope we will educate the masses in creating a dignified India. God bless you all. Jai Hind.